Ruby Franke back in court for the first time in months. Here's what you need to know about next week's court hearing and what we can expect to see.
The fact that I yell at my kids is a secret. We don't want our viewers to know.
So do you think that that's possible on Monday if they come to some sort of bond agreement that she could be released?
It's possible.
By now you're familiar with the case of Ruby Franke, the controversial YouTuber mom who's now charged with 6 counts of aggravated child abuse.
But what you guys didn't know was Chad didn't get any room. He didn't get anything. He was sleeping on the floor in the family room.
Here's a quick recap. Franke rose to fame as the matriarch of her family, posting videos of her husband Kevin and their 6 children to her YouTube channel 8 Passengers. Once boasting more than 2 million followers, the page is now defunct. In the past, Franke had caught some flack for her controversial parenting techniques like this one.
And my kids are literally starving.
Fast forward to August 2023 when we hear this shocking 911 call for the first time.
He's emaciated, he's got tape around his legs, he's hungry and he's thirsty.
The call was made from Ivins, Utah by a neighbor of Jodi Hildebrandt. Hildebrandt had been Ruby Franke's business partner, and together they gave self-help advice.
Welcome to Connections. I'm Jodi Hildebrandt. So glad you're with us.
It turns out Franke's son was being held in duct tape shackles. When he broke free, he was emaciated and weak. Both Franke and Hildebrandt were later arrested and charged with 6 counts of aggravated child abuse apiece. For his part, Ruby Franke's husband Kevin Franke claims he had no knowledge of this and was several hours north near Salt Lake City at the time. He recently filed for divorce. But let's focus on the future of Franke's case when she's due back in court on December 18th for what's called a preliminary hearing waiver. To make sense of that, we turned to criminal defense attorney and former prosecutor Matthew Mangino.
I think at this stage, there's a preliminary hearing that normally would be scheduled. And that preliminary hearing is what is referred to in a lot of places as a probable cause hearing. Is there sufficient evidence for this case to go forward? Now, not everybody charged has a preliminary hearing. You have the opportunity to waive that hearing and let the case proceed. So what you're doing by waiving is you're not admitting guilt. You're simply saying there's sufficient evidence for this case to go forward, and the case goes on to a trial, ultimately pre-trial and things like that. It appears what they're asking is, will Ruby waive this hearing? And if she waives it, will she just acknowledge there's sufficient evidence and let the case move forward in that manner?
So what would be a reason for either side to waive this preliminary hearing? Would it benefit the defense in order to waive this hearing?
Well, it depends what's been going on that we don't know about in this case. There may be plea negotiations that have been ongoing because she's been in jail since August 30th. So some time has passed. Normally, preliminary hearings or waivers of preliminary hearings happen very quickly, within weeks of the initial charges. So we have this delay. Has there been some talk going on between the defendant and the prosecutor's office with regard to resolving this? That may be a reason to waive if you've been offered a plea in exchange for waiving and acknowledging guilt. Myself, as a practicing defense attorney and a former prosecutor, I don't like to waive preliminary hearings. I think preliminary hearings are extremely important when you're looking at the total context of the case. It really gives you an opportunity to examine witnesses, to examine evidence. So if you're going forward and you're gonna fight this prosecution, most attorneys are not going to waive a preliminary hearing. I would say one other thing. Sometimes in exchange for a waiver of a preliminary hearing, prosecutors will agree to some bond. Right now, both of the defendants are being held without bond. So maybe there's some agreement. If you waive, we'll let you post bond.
Mangino says from his perspective, it would be wise for the defense to move forward with the preliminary hearing. So if we're talking about waiving the preliminary hearing, if that's something that her defense does decide to do, is it possible that that's a strategy to keep some of the details closer to the vest, so to speak, to the defense, buying themselves more time before trial and all those gory details come out?
Well, that is something that a defense could talk about, could strategize about. I mean, here I think the most important thing is, we don't, although we see a lot of it, we don't try cases in the court of public opinion. So if I were a defense attorney, I want as much information as I can get my hands on as early as possible. If I'm going to try this case, I'm not going to let a single opportunity go by where I can't examine a witness or I can't examine some evidence in this case. What ultimately happens is if you're going to challenge this prosecution, if you're not going to do it at the preliminary hearing, you're going to do it at pre-trial. You're going to file pre-trial motions challenging, whether or not there's sufficient evidence in this case, challenging, the way evidence was collected. We know what we do know about this case is come from search warrants. So we know, is there some opportunity to suppress some of the evidence that was obtained through the search warrants or any statements or anything like that. So I don't know if you're going to ultimately challenge this case, how you do it without those gory details, so to speak, being disclosed to the public. And that's really not that bad because ultimately you're not going to try it in public. You're going to try it in front of 12 jurors.
Here at Law&Crime Network, we've reached out to both Franke and Hildebrandt's attorneys multiple times, but have repeatedly been denied any interviews. Mangino says that's relatively common and doesn't mean the defense is hiding any details.
I'm not entirely surprised that they don't want to talk to the media at this point. There's a lot going on, I'm sure, behind the scenes that we don't see in this case, whether it's negotiations, whether it's your own investigation. You hire your own private investigators to find out information that might be helpful or exculpatory in this case. So I'm not entirely surprised by that. But again, that's a matter of style, and that's a matter of approach to the preparation of a case. Some lawyers are very flamboyant. They like to come out and they want to talk about it and they want to put this out in front of the public. And other lawyers, as you said, Sierra, they play it closer to the vest. And sometimes that's just a matter of style or strategy. And I don't think we can read a lot into someone who comes out talking and laying it all on the line, or someone who doesn't say much at all as they prepare their case.
And while the topic of a preliminary hearing will be on the table, so too could be the possibility of a plea deal. Is that something that we could expect to see? I mean, if Ruby Franke does decide to take a plea deal, if that's what's been talked about behind the scenes that we, the public, don't know, on Monday, is it possible that we could learn news of this, that she is planning to plea?
Well, this case, has so many moving parts to it. First of all, you have a two defendants who are high-profile defendants. They had millions of viewers on their podcasts and their YouTube programs. So they're well known. They have a following, and that sometimes when you have a high-profile defendant, that puts a little bit of pressure on the prosecutor's office because there are more eyes on it. I mean, frankly, would we be talking about this case if these two defendants were not high-profile YouTubers? Maybe not. So that kind of works into this process. Everybody wants to tread carefully because they don't want to, do something that might embarrass them in terms of public perception of how this is handled. But in most cases, 99.9% of cases, there's plea negotiations that go on. And we know, frankly, that 96, 97% of all criminal cases end up in a plea. So, I'm sure there's discussions going on. There always are discussions going on. It's very rare that you don't have plea negotiations going on from the very outset of charges being filed. Again, that might be tempered by the high profile nature of this case, but in my opinion, there have been discussions and there will continue to be discussions.
So let's say on Monday, this December 18th hearing, that it comes out Ruby Franke has decided to plead guilty. There's this plea agreement. We know all of that. Is it possible she could be sentenced right away on that court date?
I wouldn't think so. And I don't even think that she would enter a plea on that date. Now, there could be an agreement that a plea is going to be entered, but I don't see that plea being entered, at this point in time. There could be a waiver, as we talked about, and then ongoing negotiations. Sometimes there's other issues that have to be worked out. I would say if there is some ongoing plea negotiations and she waives her hearing in anticipation of a plea, that plea would be handled at a later date. And then there would be a sentencing scheduled later. Because what's going to happen is the court is going to want to conduct a pre-sentence investigation. They're going to want, their adult probation office, whatever entity it might be, to conduct that investigation because they're going to want to know more about Ruby, and they're going to want to know more about Jodi, so that they can, impose a fair sentence and make a decision whether they're going to accept the recommendation of the prosecutor's office. So even though this case, could be near some sort of plea, that's not going to happen for a while, and sentencing is going to be even later.
If a plea deal does come about, Mangino says it's difficult to predict what both sides would agree on.
That's where all the negotiation and sort of it's kind of an art negotiating pleas, because really in most jurisdictions, I practice in Pennsylvania, there are really no guidelines as to how pleas are supposed to be negotiated or how pleas are supposed to be reached. I mean, it's really the discretion of the prosecutor and in how effective the defense is in mitigating the seriousness of a case. It is really truly like kind of like an art form because there are no specific rules that govern how pleas are to be negotiated. These are 6 serious charges, aggravated child abuse, but you also look at things like a criminal history. Has there ever been any criminal activity that Ruby or Jodi have been involved in? What's their sort of standing in the community? Have they chronically had problems with law enforcement or licensures or regulations and things like that that have been investigated? So all that is going to come into play here. And that's why a judge is going to want a pre-sentence report before he or she makes any decision in this case, because they just don't know more than what's in that file right now.
As for Monday's hearing, Mangino expects something short and sweet.
I think it'll be short. I think decision is going to be made. Do you want to have a preliminary hearing? Do you want to test the prosecution's case? Do you want to contest that there isn't probable cause to move forward? Or do you want to accept that there is probable cause at this stage and waive it? And I don't think that that's going to take a lot of time unless the court would say, okay, we're going to roll right into the preliminary hearing immediately. Now, the prosecution would have to be prepared for that, and they'd have to have witnesses and all that. I don't know if that's already done. Typically, again, just from my own firsthand knowledge, in Pennsylvania, if you have a preliminary hearing scheduled, you can go to that preliminary hearing that day, have a hearing, or you could waive that hearing. You have to be prepared to go forward with the hearing if the defendant does not intend to waive that hearing. I don't know if Utah has, some sort of preliminary step that you decide if you're going to waive. If you're not going to waive, then the prosecution prepares to have a full preliminary hearing.
And for a future preliminary hearing, it's unclear how long that could take. And when we're talking about preliminary hearings, the one that jumps out to me in my head is Brian Kohberger. That didn't end up happening, but that was supposed to be a very lengthy preliminary hearing. I believe it was 5 days that they had slated for back in the summer. So I'm wondering, for a case like this, I know it's different charges, but it is still some pretty severe charges with this aggravated child abuse. Would a preliminary hearing be short, an afternoon, or could it stretch multiple days? What could we expect if they do go to preliminary hearing?
Well, again, it would depend on sort of the strategy of the prosecution, because at a preliminary hearing, as I mentioned earlier, the burden of proof is, is it more likely than not a crime was committed and that this defendant committed that crime? That's far less than what's required at trial beyond a reasonable doubt. So again, going back in my own experience as a prosecutor, I always intended to put the minimum amount of evidence on that I could to prove probable cause. Again, because I don't want to give too much information too early to the defense. So if I felt I could prove, I could show that I had probable cause with 2 witnesses or 3 witnesses, those are all the witnesses I would call. I wouldn't put my whole case on at the preliminary hearing, and most prosecutors don't. I wouldn't foresee this being an extensive days long preliminary hearing. But again, I don't know what the strategy is necessarily of the prosecutors in Utah and how much evidence they would put on. But typically, I would put on just enough evidence to prove probable cause, far from the evidence that I'm going to use to prove a guilt beyond a reasonable doubt.
Mangino's major takeaway, though, is that Ruby Franke could soon be released from jail.
They've been sitting in jail for 3 months. This isn't a first-degree murder case, and I don't know. This is Ruby's children, so I don't know that she's a danger to others. I would want to get my client out of jail if I could. Pending trial. It makes it easier to prepare for trial. And sometimes you might give up that preliminary hearing to do that. And that could be a strategy as well.
Ruby Franke's hearing is set for December 18th, while Jodi Hildebrandt is due back in court on December 27th. Reporting for Law&Crime Network, I'm Sierra Gillespie.